This is a death penalty case. He's a death penalty defendant. It's his decision.
Yes, but it says here, the trial court must either conduct an inquiry to determine whether the asserted conflict of interest will impair the defendant's Sixth Amendment right or appoint separate counsel.
So that's Mr. Demons' decision, and the last time you all got almost hysterical that you didn't even want me to talk to him about it. You want me to talk to him about it today?
But you have not conducted any inquiry, with all due respect.
The inquiry is with your client, sir.
No.
It's not my job to investigate.
The trial court must either conduct an inquiry.
The latest YNW Melly hearing got super heated when its attorneys and the judge got into a tense back and forth over one of Melly's defense attorneys.
I can tell him there's a conflict. There's a conflict, all right? The same law enforcement agency the same state attorney's office that's trying to impose the death penalty on him is conducting a criminal investigation against one of his lawyers. So I can save you all that trouble. There obviously is a conflict.
Now, Melly was called into court on Friday because of a motion for an emergency hearing. His retrial has been pushed back and back and back again. Now, first the prosecution table change, then Melly sued the Broward County Sheriff's Office for cruel treatment. Now one of his attorneys, who seemingly appears to be his favorite, could get pushed off the case. It's no secret Melly appears to take a liking to his lead attorney, Raven Liberty. Despite facing 2 first-degree murder charges and facing the death penalty, at his first trial, the two were seen on camera being chummy. Again, despite the high stakes he's facing. Now, that was all back in the summer of 2023. Fast forward to 2025, his retrial is right around the corner. But could an issue cause Melly's attorney, Raven Liberty, to be removed from the case? So here's what happened. Last month, it was reported that Raven Liberty was under investigation by the Broward County Sheriff's Office on allegations of witness tampering. It's important to stress here, she has not been criminally charged. But here's the problem. It's unclear what their investigation is all about. However, it seems serious enough for the judge to ask Melly if he wants her to stay on his case. Even the rest of Melly's attorneys were pushing to learn the full extent of the investigation, and that came to a head at Friday's hearing.
This issue, and I agree with you, it's a very important issue, but this is an investigation that you all have to conduct and a discussion that you all have to have with your client. I don't have anything to do with it.
And of course, we have no ability to investigate secret doings of the state attorney and BSO that we don't have the right to see. So I just wanted to bring to your honor's attention that it's somewhat of a dilemma here, and that you know, we'll file what we can and see what we can get. But right now, we're at a real loss to be able to represent Mr. Demings the way he needs to be represented.
So Judge, if I may add on to that just briefly, essentially because the one portion of this case that I took on and actually have been, lots of money was put into training me on this very issue of these phones, right? So I know what they would have got off of this iCloud. They would have got information regarding my emails. I'm assuming there's further emails, warrants to my email accounts. I am concerned, going off what he says, that there's communications between my experts. Almost all my communications are on my emails with my experts, motions, depositions from other cases. So there will be further inquiry to that, and I think we're granted to that. But looking at the court's own order, you had, and I forget the name of the case, but the basis was saying that it's been, what, 14, 15 months at this point? There's no imminent arrest. So I read it as you're finding that there is no criminal investigation, and that was the basis of not letting us have the affidavit. The initial time was...
That's not correct. If this was the statute, the state would have been right. I just found that the state hasn't done anything, and based on the particular procedural posture of this case, whatever it is that they got as a result of this, they got it over a year ago, so if they wanted to charge you with something or arrest you, they've had a year to do that. I'm not going to sit around and wait for them to make that decision. They obviously haven't made the decision. The statute says if there was an ongoing case, you wouldn't be entitled to any of it.
Okay, fair enough, Judge.
So I'm just complying with what the statute says.
Your Honor, may I speak?
Sure.
When we were here the first time on the case, I'm the one that brought it forward, the motion, and you asked me what my authority was. I had cited to the court the case of Rutledge versus State, 150 Southern 3rd, 830, 2014. You asked me what my specific authority was, and I said the 6th Amendment and the 14th Amendment. I'd like to read from Rutledge, if I might. At the risk of being redundant, we once again emphatically state that when a pretrial disclosure of possible conflict of interest is raised, the trial court must either conduct an inquiry to determine whether the asserted conflict of interest will impair the defendant's Sixth Amendment right or appoint separate counsel. So with all due respect to this court, Your Honor, that's your job, is to find out whether or not there is a conflict and for you to help in the investigation. We don't have the power. Without the court's help, we'll never know if there's a conflict until possibly it's too late. So you are the person that is supposed to look into the matter for us.
I don't agree with you at all, sir. Your case says Mr. Demons is entitled to be told that there's an ongoing investigation. There is an ongoing investigation, and I told him that the last time I had a discussion with him directly. After that, Figueroa Sanabria completely controls. This is a death penalty case. He's a death penalty defendant. It's his decision.
Yes, but it says here, the trial court must either conduct an inquiry to determine whether the asserted conflict of interest will impair the defendant's Sixth Amendment right or appoint separate counsel.
Well, that's Mr. Demons' decision, and the last time you all got almost hysterical that you didn't even want me to talk to him about it. You want me to talk to him about it today?
But you have not conducted any inquiry, with all due respect.
The inquiry is with your client, sir.
No.
It's not my job to investigate.
The trial
your case.
court must either conduct an inquiry.
Yeah, that's with Mr. Demons. That's the inquiry.
Well,
I
you're
can
not-
tell him, there's a conflict. There's a conflict, all right? The same law enforcement agency the same state attorney's office that's trying to impose the death penalty on him is conducting a criminal investigation against one of his lawyers. So I can save you all that trouble. There obviously is a conflict. Whether Mr. Demons wants Ms. Liberty to continue or all of you to continue, that's his decision, but there's nothing else I can do about it.
So what's the resolution that Melly's defense team is asking for? Well, as they've made it clear, they want the judge to step in.
What is it you want me to do, Mr. Anderson? You want me to start deposing witnesses?
Deposing witnesses have
You
inquired.
want me to start deposing witnesses?
I want you to inquire of the state what evidence that they have of a conflict, so we know, in fact, that there's a conflict or not.
The state says there's a conflict too. You
Well,
read their pleading.
they say my client,
Believe them?
they say my client's
Hold on,
guilty,
one at a
but he's
time.
entitled to a trial first.
They filed a motion that said I'm supposed to remove her. They think I get to decide who's Mr. Demons' lawyer is, not Mr. Demons. I couldn't agree with that. I couldn't disagree with that more. It's his decision.
I believe, as the court, you have an obligation to ferret out what the conflict is so that we can make an informed decision. Right now, we can make no decision. Right now, we can file no motions because we don't know whether we're subject to the conflict at all. Right now, our hands are tied. It's up to the court. You're the gatekeeper for all. I'm imploring the court to find out what the nature of the conflict is so that we can advise our client. Right now, you're just saying to our client, hey, the state says there's a conflict, so you could get rid of your lawyer or keep your lawyer. That's not enough. That's not a Sixth Amendment protections. You want him to make a decision in a vacuum. This is a murder case.
Sir, with all due respect, this isn't a vacuum. He can sit down with Ms. Liberty, and you can sit down with Ms. Liberty. She's well aware who she's emailed. She's well aware who she's called. She's well aware what's on these records. So talk to your. It's incumbent on you all to fully inform your client. That's not my job. That's your job.
Well,
So tell him what's on there, and then tell him what the conflict is, and he makes a decision. I had this discussion with Mr. Demons. The conflict is, at some point in the proceedings, is Ms. Liberty going to make a decision that's not in Mr. Demons' best interest, but it's in her best interest? Okay? You all know what you're doing. I'm not going to do your job. You have to do your job.
No job, Judge. With all due respect, I want you to do your job. And I don't believe the court is. I think the court is shirking its responsibility.
I disagree with you, sir, but you can file whatever appropriate written motion you want. I'll give you a hearing on it, and then you can seek appellate authority to a higher court if you think I've done something wrong.
Thank you.
Will the court at least inquire from the state if the investigation is still ongoing as we sit here
It
today?
is ongoing. They told you that the last time.
It's still,
You said that last time, yeah.
still ongoing.
It's still ongoing.
Yes.
And have there been other search warrants and affidavits?
I have no idea, sir, but this is a discussion that you all need to have. I don't have anything to do with this.
We can't discuss if we don't know the nature of the conflict that they're alleging, other than she's under investigation. That doesn't cut it, Judge.
They said, hold on, sir.
I'm
Again,
sorry.
with all due respect, they told you the last time, on the record, it was regarding this case, because I asked them. I said, are you investigating Ms. Liberty regarding alleged criminal conduct that has to do with this case, that has to do with Mr. Demons? And they said, yes. So that's what it's about.
Well, then under discovery, for Mr. Demons, they're required to give us that information. Anything that is relevant to the guilt or innocence.
Of Mr. Demons.
Yeah, well.
I agree with you.
Okay, and if it's related to the murder case and the tampering case, under 3.220, they gotta give us that
So
information.
file a motion to compel under 3.220.
Okay, we will.
With particularity, tell the state, this is what I want. Either they're gonna give it to you or not, and if they don't, set it for a hearing
Yes, sir.
on any available date. I'm imploring you all to set these for hearings. That's why I keep giving you dates for all pending motions.
The difficulty is, Your Honor, that since we're on notice of a conflict, a potential conflict, technically, we should not be filing any additional motions until that issue is resolved. I think we're bound by the Florida rules of ethics.
Okay. Anything else from the defense today?
No, sir.
Okay.
And while that essentially wrapped up Melly's hearing, there was still one more thing.
Defense, let me, Mr. Adelstein or whoever else wants to answer this. At 1:30 this afternoon, I have to deal with Mariah Hamilton. I have some motions on her behalf, and so she's going to be present. I think your client's entitled to be present if he wants to be, but if he doesn't want to be, he certainly doesn't have to be.
He wants to be present.
We'll all be here, Your Honor.
At 1:30.
Thank you, Your Honor.
Yep, so Melly wanted to attend the hearing of his ex-girlfriend Mariah Hamilton after she was thrown into jail 2 weeks ago. Now, Mariah is very important to the prosecution's case. In Melly's first trial, the prosecution said Mariah and Melly spoke on the phone after the murders of Anthony Williams and Christopher Thomas Jr. But a bigger issue was that she didn't testify in his first trial. However, her mom did.
When you first took the stand, you said, "I feel threatened."
Yes, sir, I do.
Who do you feel threatened by?
Objection, Your Honor. Christine Bradley, the prosecutor's office.
This prosecutor.
Yes, I did.
Thank you.
So that was back in June of 2023. Fast forward to 2025, last month, Mariah was arrested for civil contempt after she left the country on a birthday trip. I spoke with her attorney, Chris Barris, who told me at the time there was a whole issue on whether or not there was a warrant out for her because she didn't testify in Melly's first trial.
We talked about the possibility that there might be a warrant in existence. The prosecutor had indicated to me at one time that there was a warrant. Other law enforcement had indicated to me that there was no warrant that they could find in the warrant system when they checked. So we did talk about that. I did not think it would be a good idea to travel internationally because what happens is when you return to the United States, even before then, immigration, U.S. immigration, that is, will check the manifest of an airline for every passenger to determine if there's any warrants or any other holds on them. And I couldn't say either way whether there was a warrant. So my advice was not to travel at all.
So Mariah was held in jail for 2 weeks. But this past Friday, not only did Mariah appear before the judge, she was placed in the same room as her ex, who she hadn't seen or spoken with for a while, according to her attorney. But Barris had a very important question for the judge.
I have had some time to speak with Ms. Hamilton. The way I see it, Judge, there's only really one issue here today for the court to decide, and that is whether Ms. Hamilton was legally obligated to appear. The issue is not, whether Ms. Hamilton knew that the police or the prosecutors wanted to talk with her. And those are different issues. We're talking about legal obligation, not maybe a moral obligation or some other obligation. My answer to the question is no. She had no legal obligation to appear. Defense has evidence that she was not served, and I hope the court understands I was not Ms. Hamilton's attorney when I believe the former prosecutor filed a motion for an order to show cause. I wasn't the attorney back then, so I don't know the events that happened back then. I'm not even sure. I haven't seen a show cause order issued by the court.
I don't think there is.
Well, that's another problem, sir, I have.
I agree. I don't think she's ever been held in direct and indirect criminal contempt. She's in custody pursuant to 942.03 of the procedure for securing a witness that may be coming from outside of the state.
Well, and I'm not sure, I did see that document. It's the most curious document I have ever seen. A witness coming from outside of the state? What, again, there's a constitutional issue with that writ or warrant or whatever we call it. No notice, no opportunity to be heard. I don't have any facts that have been, I should say, the state has not presented me any facts that she was ever out of the state. So also, that document, if it is a proper writ or warrant, is stale. That document addresses a trial that happened in 2022, and I believe, I don't have it in front of me, I believe it orders that Ms. Hamilton be arrested and detained for no longer than 60 days during the period or the pendency of that trial back in 2022. So it's a stale warrant to begin with. I don't see any legal basis for her to have been arrested or to remain in custody. And you know, in my initial motion, the emergency motion I filed, I did ask ultimately for an ROR. I don't think that's appropriate. I think the court must release her, no conditions. I mean, if the state feels that she's a material witness, I suppose they can serve her with a proper subpoena right now in court or before she leaves custody. I do have evidence. I can give the court evidence, but I believe, you know, it's really the state's burden to show that there was a valid subpoena served upon Ms. Hamilton as the basis for this arrest.
Well, listen, I agree with you. That's why I'm going to release her.
Well, thank you,
She
Judge.
can't be held. But what we're doing going forward here is, and again, so the record's clear, I'm only proceeding under 902.15. When a defendant is held to answer on a charge for a crime punishable by death or life imprisonment, that's Mr. Denver's case.
Right.
The trial court judge at a preliminary hearing, that's what we're doing right now, may require each material witness to enter into a written recognizance to appear at the trial or forfeit a sum fixed by the trial court judge. Additional security may be required at the discretion of the trial court judge. The state's telling me that she is a material witness, that they do intend for her to appear, so I'm probably inclined to follow the state's recommendations we did with the other similarly situated witness, which is ROR her, put her on pretrial with an electronic monitor, and I'll waive the cost of the monitor. The only thing that she has to do is if she's served either by the state or by the defense, by any party, she just has to answer the summons, just like anybody else. I mean, the rules apply to her the same as everybody else. I agree. I don't think there's any legal basis to hold her in custody at this point, unless someone shows me something different. But I couldn't find anywhere in the court record where Judge Siegel or Judge Murphy or any judge found her indirect or direct inmate contempt. This was merely a question of a non-cooperative material witness.
So good news for Mariah, she could get released.
And just to be clear, this was all taken up with all the documents that these motions are asking for. Her counsel, if it was previous counsel, they had all this because it's all in the appellate record, and you can pull it all up with the subpoenas and testimony by the state's investigator, transcripts, all of that is there that discusses what efforts were taken, and Judge Siegel had that hearing, ruled in favor of the state, it was taken up, and it was denied on the merits.
Right, I understand. But I mean, at this point, do you have any objection to me proceeding as I articulated?
No, Your Honor.
Okay. Do you have any objection?
Yes, I do. I think the state created this whole problem, and I don't think they should benefit or be punishing Ms. Hamilton by requiring a monitor or any kind of restriction on her freedom. The reason I say that, notwithstanding any appeal that was decided in favor of the state, there was a lie told. There was false information regarding the subpoena that was purportedly validly served upon Ms. Hamilton. And I don't think there's a basis, or it seems quite unfair to be punishing her by restricting her freedom for something that we haven't even looked at in this hearing.
Well, 902.15 contemplates something happening in the future. They're talking about her being a material witness in a trial that's going to take place in the future. There's nothing to do with this taking place in the past.
Yeah, I understand, Judge, but all they have to do is serve her with a proper subpoena right now. She is obligated then to appear or suffer the consequences for failure to appear. That's what I'm asking for. I'm asking just release.
I think they already tried it that way.
Well, no, they didn't.
And then there was a warning for 2 years.
Why do you think that, Judge? Because I don't see that they did try it that way.
Well, I don't know. This is the first time law enforcement agencies called me on a Sunday at my house to tell me that someone's at an international airport with an outstanding material witness warrant on them, and asking what I would like them to do about it. And my answer was, I don't know anything about it, so I don't know what it is you would like me to do about it. So I've been coming to work in this building every day for a long time. I've never seen this before.
And nor have I, and I've been doing this for 30 years. I've never seen this before.
But she does qualify under 902.15. So listen, at this point, it would be over your objection, and I'm not foreclosing you. You want to file the appropriate written motion. I'll give you an opportunity to have a hearing, an evidentiary hearing. You can present anything and everything to me that you would like. I'll give the state the same opportunity to present whatever evidence, witnesses, and testimony they want. And it could be that I might agree with you and decide that wearing a monitor is a unreasonable condition. But at this point, over your objection, I'm going to follow the state's recommendation. I'm going to ROR Ms. Hamilton so she's not in custody, but she's going to have to sign up with pretrial. They're going to have to verify her address, and then they're going to put her on an electronic monitor. That's the only restriction. I'm not putting any other restrictions on it because she's not charged with any independent crime. But if she's served with a subpoena, again, by any party, she just has to answer the subpoena, just like any other witness. What makes it unique here is that 902.15 allows this procedure only in a case that's punishable by life or the death penalty, and that happens to be the case that we're involved with here. So I'm going to follow what the statute says. So, Ms. Wilcox, it's an ROR, standard pretrial with an open schedule. There are no other special conditions except that she has to check in with pretrial as they might require. I will waive the cost of the electronic monitor. And Ms. Hamilton, you got to show up, someone subpoenas you for a deposition or a hearing or a trial, whether that's the state or whether that's the defense. You just got to answer the subpoena. As soon as this case is done, then this obligation in 902.15 will also be. Right?
But bad news, she has to wear an ankle monitor.
Ms. Hamilton, a BSO is going to get your address because pretrial needs to know. I'm not going to put your address out on the public record right now. But what city do you live in?
Vieira.
Where?
Vieira, Florida.
Vieira, Florida.
Yes.
Okay.
So,
Her name is Mariah Hamilton.
Judge, does Ms. Hamilton, she's free then at this point?
Well, I think BSO has to process her out. Someone from pretrial is going to have to come talk to her. They get all of her information. They have to verify her address. Is it a house or an apartment?
A house.
Does someone else live there besides you?
Yes.
Someone that can verify the address there?
I live with my dad.
Okay, so as soon as they talk to her dad and they verify the address, they're going to put the ankle monitor and she'll be released.
Okay.
So
Okay?
what happens next? Well, Mariah had to sign a written promise she would appear for all future court dates and stay in touch with her attorney and the prosecutors on the case. As for Melly, he'll remain behind bars, but we'll be back inside that courtroom for another hearing slated for next week. Melly is set to appear before the judge again on Tuesday, February 18th for another motions hearing. His retrial is a few months away. That's scheduled to begin in September of this year. And as of this recording, Raven Liberty is still listed as one of his attorneys. Reporting for Law and Crime, I'm Elizabeth Milner.